Good afternoon and good evening. Today is part 2 of 20 short videos of Club Cup. Enjoying the videos. Hey, honey. What's up?
I believe I'm going to just have everyone log into Zoom this afternoon and then set the matter, if necessary, for a hearing after the people have had an opportunity to review the evidence. Ms. Ritter?
Judge, thank you. So, Your Honor, the court is correct. The people have not had an opportunity to review the evidence relating to this hearing. I did have an opportunity to speak with Ms. Robinson during a brief break from the court. Ms. Robinson being, I guess, agitated with how the people wanted to proceed as far as holding this probation violation hearing and giving the people an opportunity to give a sound argument and decision in making with this process. She wasn't satisfied with what the people were trying to tell her. So just so the court is clear, and just so Ms. Robinson is clear, it is up to the people. From my understanding, it's up to the people as to how they're going to proceed after viewing the evidence, whether they're going to proceed or not to a probation hearing. And from my understanding, Ms. Robinson has been in contact with Ms. Lurst. So Ms. Robinson is, I guess, has confidence in the probation as to handling this hearing opposed to the people.
Ms. Lurst is not an attorney today. She wasn't one yesterday, and she won't be one tomorrow. I could care less. What's going on? Why is the officer talking to the witness?
Your Honor, I'm telling her to take her arms down and she's refusing to do so. That's why I was talking.
Because it's time to go. I've been trying to.
Ma'am, who you talking to? Who you talking to? Who are you talking to? Who you talking to? Who you talking to? Who you talking to? Who are you talking to?
Her and her daughter every day.
Officer, you're going to take her in the back.
Right.
She's going to stop.
Go, I mean, because it's
You're
got to
going to
go.
stop. You're going to stop. You're going to stop. You are going to stop. You're going to stop. Ma'am, you're going to stop. Stop it. Stop it. No, stop it. Stop it. Ma'am, stop it. Now, this is completely and absolutely unnecessary.
Why is that? Every day her and her daughter harass me. They doing things. What y'all waiting for them to kill me? Every day.
Let me tell you what I'm getting ready to do. I'm getting ready to get in my car and I'm getting ready to come down to the court. You're gonna put the, we're not having no hearing and it ain't gonna turn out for you. I'm getting ready to appoint, I'm getting ready to appoint you counsel, ma'am. I'm getting ready to appoint you counsel. That's what's getting ready to happen. So you think it's good for me to come down to my car? You think that's...
Wow, that police is that the judge is corrupt. Damn. She doesn't want to hear anything. Wow.
Weeds on his property to grow out of control, violating a local law against noxious weeds and vegetation. Chowdhury was undergoing treatment for lymph node cancer that left him too weak for yard work. His son, Shabir, who usually maintained the property for him, was out of the country when police issued the ticket. Shabir cleared the overgrowth when he returned to the U.S. Father and son are hoping for leniency today from Judge Alexis Kropp, considering Chowdhury's medical condition and that it's his first offense.
All right, you have a ticket for failing to keep the fence, walkway, sidewalk, or alley free of weeds, trees, or other nuisance vegetation. The first offense, civil infraction, you complete responsible, responsible with an explanation or not responsible?
I am a cancer patient, very old man, and I am a cancer patient. I was then very weak, and she very weak. And this time of rainy season, I cannot look after this thing.
Chowdhury's labored breathing is apparent as he explains how his illness and the rainy weather affected his landscape. But the judge refuses to cut him any slack.
You should be ashamed of yourself. If I could give you jail time on this, I would.
The judge is not feeling forgiving. Quite the opposite. She's talking about jail time for an elderly cancer patient for a minor civil infraction.
If I could give you jail time on this, I would. The fine is $100 paid by February 1st. You've got to get that cleaned up. That is totally inappropriate.
Oh my God.
Chowdhury is stunned at the judge's outrage. So son Shabir steps in to reiterate his father's situation and to tell the judge that the weeds are already cleared.
Oh, okay. Like, is it ma'am forgivable because my father is currently sick and we cleaned that after?
See that photo?
Yes.
I am very sick, man.
That is shameful. Shameful. The neighbors should not have to look at that. You should be ashamed of yourself.
Yes, I am sick.
You're going to jail.
Judge Kroc closes the hearing with a threat to send Chowdhury to jail if he returns to her courtroom. The rant went viral within a week, with many reacting to Judge Kroc's treatment of Chowdhury with disgust. An online petition calling for her removal from the bench has over 250,000 signatures. The judge released a statement apologizing for her behavior towards Chowdhury and reported herself to the Judicial Tenure Commission. The Hamtramck City Council later voted to censure Judge Kroc. Chowdhury's $100 fine was paid 2 days after the hearing.
Wow.
Court will call Charles Taylor, 22M2517. I have Mr. Taylor on the line. Hello, Mr. Taylor.
Good morning, Your Honor.
And let me just take, good morning. Let me take a look here. Last, we were in the arraignment center. At that date and time, we set the matter over. You were going, isn't marked, so I don't have good information on whether you're going to be or a public defender. Had you thought about it?
No, I'm going to represent myself, sir. Not only that, but March would be outside of your jurisdiction to prosecute me because you have 6 months to the date of that citation. So I will represent myself since you guys have a clear misinterpretation of the law and what my rights are.
So you don't want to get an attorney?
No, sir. I think I just made that clear.
Have you talked to the DA to see what they want to do with the case?
No, I mean, that's the problem with Colorado law right now. And the only county in the state that's spoken out about it is you guys, but you have a divided prosecution where 50-year-olds have a common sense of the law, and then you have 25-year-olds that are letting your last 3 people out on PR bonds. So you guys are really just as twisted as Boulder County right now.
I have a question for you.
No, I actually have a question for you. Are you under the influence right now of medication, drugs, or alcohol?
Me?
Yeah, because I'm very, very concerned right now. Your mouth has been all over the place. Your nostrils have been all over the place. Your body language has been all over the place. You can't sit still. You're confused at every single case that's been brought to you. You obviously don't understand the law. You don't understand jurisdictional zones. You guys pretend that you guys are against this liberal bullshit that Colorado has been doing for the last 3 years. But here you are right now playing Boulder County fucking games. So I'm going to ask you again, are you under the influence of drugs, alcohol, or medication? If you have a medical condition, I sincerely for real apologize, but something is clearly going on with you.
Ms. Love?
Judge, this was the same behavior that was happening in Division A. I'm moving to dismiss the case.
Ms. Love is going to speak now, Mr. Taylor. Ms. Love is going to speak now, Mr. Taylor.
I'm not condoning this behavior by any means, but I'm moving to dismiss the case. I'll submit a written motion. I think we can terminate the call.
No, it's because you know my rights are, and you know I'm going to make you look stupid because I have a better education than you.
Mr. Coates, Mr. Taylor, rather. Mr. Taylor.
See, you don't even know my name.
You're not allowed to record. And if you're recording, you're in contempt of court, and you may not do that. So we are
You're recording
of a WebEx appearance, but you may not record this proceeding.
You're recording.
I was asking Ms. Love if she had any concerns about whether I was under the influence of drugs or alcohol.
So my concerns aren't her concerns. My concerns isn't her concerns. My concerns are my concerns.
Judge, I don't have any concerns about that at all. Like I said, when Mr. Taylor was in Division A previously on this case, it was the same sort of ranting that he engaged
because
in.
you guys give me a citation 30 miles outside of the county that you guys are in.
Court. I have no concerns about that. Presently, I'm actually in person viewing Judge Briggs, so I don't have any concerns about that at all. Although
Again,
I'm not condoning
my
the behavior
concerns
that happened.
aren't your concerns.
I do think just given judicial efficiency, the people are going to move to dismiss this case, and I'm submitting a written motion.
All right, Mr. Taylor?
Yes, sir.
The case is being dismissed, and you're excused from further involvement.
Thank you very much, and I apologize again if it is a medical condition. And if it's not, you need to go see a doctor.
Thank you.
Damn. Wow. Amazing. Mm-hmm. If you want to come up, I said I send you the link. Next video.
I think there's been some. I think there's been
a misunderstanding, Your Honor.
So do I.
Your Honor, I'm going to ask
Wait, do we have any indication that he has any other case pending in Wayne County Circuit Court, Mr. Deputy Marquez?
No, sir, not that I see. None but the current stuff.
Lisa, do you have any indication on anything, including the lien that you're either have run or are running or about to run, that there's any other hold?
No, the lien is printing down there in the courtroom right now. And I looked on the Wayne County site. It only shows these two cases it's held on.
So the problem is somebody had made an assumption, and my father used to tell me what would happen if you made an assumption. And it's not a good one. This guy's been he's been sitting in jail for 2 days. Unless there's a hold, I want him released immediately.
Thank you, Judge.
Okay?
No tether?
Well, no, he's still gonna have his tether. I still want the tether on him.
Wait. Yes, Judge.
I want the tether on him still with the same tether conditions. And we will send those back if we need to. No contact with Isabella Cavalin or prosecution witnesses, no alcohol, no drugs, no firearms, no dangerous weapons. He's not to be within 2 miles of that individual's residence or place of employment, and he was not to be released until fitted with a GPS tether. So what I would like is, do you still have the tether right now, Mr. Elliott?
No, they cut it off, Your Honor.
So they need to get that back on him with those same conditions. And would you tell them the judge would really appreciate it if they would expedite it, since he's just spent 48 hours in jail, or thereabouts 38 hours in jail, that he shouldn't have spent 38 seconds on?
Yes,
So,
I'll get with my sergeant ASAP.
So Lisa, let's send that back. The minimus, we'll just do an amendment and say the defendant has posted bond, because he has, February 28th of 23. I'll just make a note, and then you can put in the conditions to make sure they get all the conditions in here. Defendant taken into custody on April the 4th. It appears that was in error. Defendant to be released immediately, but I need you to have those. But this is not right. Look, they got to be more careful down there. I mean, this guy now, he spent 38 hours in jail. I wouldn't want to spend 38 seconds in jail, let alone 38 hours. Now, he's got himself into trouble, but he still enjoys a presumption of innocence here. And now somebody's going to tell me they can't get the tether back on for a day or 2 or 6, and that isn't right either. So do whatever you got to do. Tell him the judge said he wants this guy fitted with the tether first and foremost right now, as soon as possible, so he can get out of there, because he should not have been in custody for the last 38 hours, as far as I can tell.
Thank you, Judge. I'm going to give my sergeant a call right now.
And if they need to talk to me, they can call the court and I'll talk to them. But you got to be careful. Thank you very much, Deputy. Have a good day.
Thank you, Judge.
Thank you, Mr. Baldwin.
Thank you, Your Honor.
Thanks a lot, Mr. Elliott. Stay out of trouble, though.
I will, man. I'll talk to you.
I don't want you to say a word. Stay out of trouble. Don't say a word. Good luck.
Yes.
I'm trying to get him out of a breakout.
Yep. Very good advice.
Two-month-old cat.
I'm sorry, Your Honor.
No, I mean, I know you're sorry. You're saying you're sorry you did it. I'm asking why. Why would you do that?
I was under the influence of drugs.
But you were eating at Sonic when this happened?
Yes, ma'am.
What drugs are you saying you were under the influence of?
Methamphetamine.
Okay, so why did the meth make you strangle a cat?
I'm not sure, ma'am. I also have mental health issues.
And what's the mental health issues?
Bipolar.
All right, so again, we're back to the point. So I'm assuming, and correct me if I'm wrong, you were not on your medications?
No, ma'am.
All right, so you take meth. So how does that translate into strangling a cat?
Your Honor, there's no good explanation for strangling a cat.
Well, no, I mean, here's the thing. Sometimes you're on drugs and you do certain things. So I'm just trying to figure out if meth caused her to strangle a cat, or is there something else going on?
According to the diagnosis from the psychologist, there was also some issues with bipolar disorder. When you mix being bipolar with meth and homelessness, it's all just a bad combination. I've asked her what her plans for the future will be. She's indicated she wants to work as a waitress. She eventually, once she's done with prison time, will live with her mother. She wants to avoid the bad people and the bad situations that she was involved with.
Okay, so how does taking meth, being bipolar, equal to strangling the cat?
As we said earlier, there's no excuse.
But no, I'm asking her.
Sure.
Like, what was your thought process? Because what I'm reading is there were 2 tabby cats running around. And so what go from 2 tabby cats running around enjoying themselves to double knotting a rope around one tabby's neck?
I don't have an excuse, Your Honor.
Well, I mean, I know you don't have an excuse, but I'm trying to figure out what was your thought process?
I'm not sure what my thought process was at the time.
Well, I mean, did you...
Wow. What do you guys think about it?
In 23 CR 10004. I just have one question. How old is the child in this case?
Mr. Ashbaugh.
Mr. Ashbaugh, you're
4
still on
years-
the
four-
oath. How old is the child?
4 years old, about to turn 5. I have a son on the way as well.
All right. So here's the court's question. I've read the police report and I understand the nature of the report. What is the concern with him dropping the child off? You say the child has to be there by what time?
At 7 o'clock.
What is the current concern with that small window for him to drop the child off and bring the...
Judge, so this was a random shooting. Again, my concern is that due to the nature of it, which is random, these were people that he had no contact with before, as far as we can tell. There was no reason for the act to have happened, so it's just a concern just for general public safety, the random nature of the crime.
Okay, I understand that, but he's on full house arrest. And how long has he been on full house arrest? How long have you been on full house arrest, Mr. Ashbaugh?
Around over 2 years, ma'am.
All right. So, from the court's perspective, people cut off monitors every day. They do. But I'm going to allow him to take the 4-year-old because I think that will alleviate any more issues if there are mental health issues involved for him to just drop the daughter off. He's not asking to even do pickup, just to drop her off. And
Yes, ma'am. Thank you so much, Your Honor.
Sure. And that's, thank you. And that small window is just an hour. So where are you dropping her off to? What's the location?
Interesting. Good judge.
He's gonna lose his job.
I just lost my old job because I got locked up.
I think
there's been some, I think there's been
a misunderstanding, Your Honor.
So do I. I don't understand this. I just don't understand this. So the problem is somebody had made an assumption, and my father used to tell me what would happen if you made an assumption, and it's not a good one. This guy's been he's been sitting in jail for 2 days. Unless there's a hold, I want him released immediately. It's just so sloppy.
Image.
For your first appearance, we'll be in front of the judge. So I'm asking you to step up here so you can go through this process.
I'll go ahead and spoil a little for you. This goes downhill real quick.
Stephen, this is about to go really poorly, really quick. Come up, sir. It's going to go bad for you regardless. Just wait.
That's the judge speaking. No video of him, but I'll put a picture of him on screen. How quick do you think he will have this defendant arrested? Put your guess in the comments.
You now stand charged with your third case, sir. What? You now stand charged with resisting arrest and failure to identify oneself as a fugitive from justice. You're now facing an additional year on each case. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
I don't understand. I don't understand.
Sir,
You do not have
it to you right
I
now.
have the right to arrest me. I did nothing wrong.
Let's see.
I did nothing wrong. You do not have this courtroom. You do not have the right to arrest me. You do not. Are you acting under your constitutional oath today? Are you?
Yes.
You are? Okay, well, good. You are in agreement with the prosecutor, right? I make a motion that this case be dismissed.
I'm about to hold you in contempt of you.
In order for there to be a crime, there has to be an injured person. The only person injured is me, and I have the scars from the policy officers pulling me out of my car without even telling me why. I don't understand.
You have the right to remain
I do not
silent.
understand.
One more word and
I do not. You can't do that. In order for
If you guessed 1 minute and 30 seconds, you are a winner. Now guess how long it will take him to get tased.
for there to be a crime, you're not, this is against my constitutional rights.
Okay, you know
Do
what?
I have a witness that they are committing treason? Do I have at least 2 witnesses? Do I have at least 2 witnesses that they are committing treason? This is treason. They're violating my rights.
This next part off camera, unfortunately. The audio, however, is still priceless.
They are violating my rights.
Hey,
Look, see, that's what I'm talking about. Look.
Put your hands behind your back.
No, sir.
Put your hands behind your
You're
back.
violating my rights, and you all know it. The public prosecutor is here, a court reporter.
Put your hands behind your back.
I'm not doing anything wrong. Do I have 2 witnesses? Do I have 2 witnesses that say that they're committing treason? Please raise your hand. Do I have 2 witnesses that they're committing treason? I have it. Are you raising your hand?
If you guessed almost exactly 1 minute from his arrest, you win.
Put your hand. Put your hand.
Do I have 2 witnesses? Do I have 2 witnesses that they're committing treason? Raise your hand. Stand up. Stand up for America. They are committing treason. They're committing treason. Raise your hand. No way. They are violating the Constitution. They are violating the Constitution.
Stop. I'm trying to lift you up properly, but you will not stop resisting.
Man.
Let me tell you something. It's make me sick. You know? Number one, you don't have to show your ID card. You don't. You don't have to. The judge is a hypocrite. You know? If there was people care all about him, they would stick up for him. That guy did right. He speak up to himself. Yeah, but he's not in a position. He's trying to explain the judge, you know, and the judge don't listen to him, you know. If there was an artist people there, for example, like you was there or anybody was there, it'd be a different story, you know. It would be a different story. The judge would change his mind right away if they have people like the 1A goes inside, you know. Way corrupt. Way corrupt. Way corrupt. Hey, where's that? Can you find this full video? It must have a full video. Very corrupt, you know. That video I just played.
He ate different people. He kept going until he got to the end, and there was no more bodies to hit. It was intentional.
If you are allowed to represent yourself in this case, sir, you will not have attorneys assisting you. They are gone from this case. Do you understand that?
I think I will probably be better served representing myself.
He told Erica that he was gonna find her and he's gonna kill her.
I'd like to provide the defendant and the court.
So that had to be said. The defendant. I got one ear that work and I heard that.
This is to benefit you,
So
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness.
me.
Take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
The jury quickly found Brooks guilty of all 76 charges against him, and he was given 6 life sentences, plus more than 700 additional years in prison.
Interesting. Ten more videos to go.
Sexually oriented child victim offense. As such, you will be a Tier 3 registrant for your lifetime with in-person verification every 90 days. Failure to register, failure to verify residence at the specified times, or failure to provide notice of a change in resident address or other required information as described above will result in criminal prosecution. This court is so sick and tired of seeing adults ruin and abuse children. These are literally just one step from being babies. They come to a daycare, those parents struggle so that when they release their children to someone during the day, they have some semblance that that child is going to be protected and safe. Not let alone 2 of their children being raped by your own admission, sir. For sexual gratification, you violated a 4-year-old and a 6-year-old. I do not know at this time what the total ramifications will be for those 2 young children, but there isn't anybody who doesn't understand now the developmental phases of children take place from 0 to 6 years old. You can't even know what damages you've done for sexual gratification. This to me is so mind-boggling that you used and abused two little children like they're inconsequential beings. Those are human persons with human dignity. The mere fact that they're small little people that can't fight off adults, that's why an adult left them with adults. I'm going to tell you something, Mr. McFadden. There's no free rapes in my courtroom. On count 1, I'm sending you to prison for 11 years. On count 4, I'm sending you to prison for 11 years. They will be consecutive to each other for a total of 22 years. You have 32 days jail credit. At this time, the court finds it necessary to protect the public from future crimes, to punish the offender, and to find that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger the offender poses to the public. Folks, if you see it, you smell it, you know it's happening, you report it. These are little children that are the future. I hate to sound so cliche, but the children are our future, and if we're destroying them, we have no future. And this ends in this courtroom.
Well said.
Criminal complaint this morning. You're being charged with count 1, attempt murder, victim 60 years of age or older, a felony. Count 2, battery on a protected person resulting in substantial bodily harm, victim 60 years of age or older, a felony. Count 3, extortion by threat, a felony. Count 4, intimidating a public officer, a felony. Count 5, 6, 7, 8, and 9 are all battery on an officer, the same named victim. Oh, and by the way, I do not know any of the other victims named in the criminal complaint. Those are all felony offenses. Count 10, performance of act or neglect of duty and willful or wanton disregard of safety or persons of property resulting in substantial bodily harm or death, a felony. Battery on a protected person, count 11, that's a gross misdemeanor offense. Count 12, battery by a prisoner, a felony. Count 13, unlawful act related to human excrement or bodily fluid, a felony. All allegedly occurring on January 3rd of 2024. Do you understand these charges?
Yes, I understand.
Both good, Judge. Both so far is good. This judge and the other judge was good.
Video from Las Vegas shows the moment 30-year-old Deobra Redden leaps over the bench, tackling Judge Mary Kay Holthus. Redden is a 3-time felon, in court this time for sentencing after pleading guilty to attempted battery with substantial bodily harm. Redden was not in custody at the time, and moments before the attack, he calmly asked the judge for probation.
I feel like I shouldn't be sent to prison, but it's appropriate for you then. You have to do what you have to do.
But the judge said probation wasn't working.
I think it's time that you get a taste of something else, because I just can't with that history. In accordance with the laws of the state of Nevada,
Redden tackled the judge to the ground before being wrestled off her. Judge Holthus was injured but not hospitalized. A courtroom marshal was treated at a hospital for his injuries. Redden is in jail now, facing multiple new charges, including battery on a protected person. He's due back in court next week. Carter Evans, CBS News, Los Angeles.
What an idiot the guy is. Idiot. Big idiot, you know? Very idiot. You don't take the judge. You know, when they take the judge, you get more time. Idiot.
Court, Judge Perry Stout entered guilty pleas to money laundering and possession of marijuana with intent to distribute. Stout's guilty pleas came in Johnson County Criminal Court in Mountain City. News Channel 11's Jeff Keeling reports the former judge received strong comments from both the prosecutor and the judge in the case.
Perry Stout wasn't on the bench Friday in Johnson County Court. The former judge was facing it, pleading guilty to possessing drugs with intent to distribute and a money laundering count that will bring a sentence of 8 years.
He truthfully admitted to having invested in Marshall's marijuana business for the purpose of earning profits, going back as far as 2022.
That's 1st Judicial District Assistant DA Dennis Brooks. He said Gary Marshall was already under investigators' microscope when he began frequently visiting Stout at the courthouse after Stout was elected Sessions Court judge in September 2022.
We don't normally see judges associating with drug dealers, and seeing it happen naturally raised suspicions.
Brooks said months of investigation showed Stout made money as Marshall brought marijuana and THC products back from Michigan. Stout often didn't tap into that cash.
Otherwise, Marshall said Stout simply told him to reinvest his profits in the business.
When Marshall cooperated over the past month plus, he said Stout took out money to finance his election bid.
Everyone in Johnson County who passed billboards promoting Perry Stout for judge were looking at billboards paid, at least in part, by dirty money.
Judge Lisa Rice called Stout's trajectory incomprehensible after years spent building a successful law practice.
It's regrettable and beyond comprehension descriptions of how it's happened.
Brooks said despite stepping down early in his term last year, investigators seized video showing Stout with Marshall
telling this drug dealer that by April of 2024, Mr. Stout would need a cash infusion for his planned run for judge this year.
Instead, by the end of April, Stout should know the specifics of his sentence. Rice set sentencing for April 22nd, and Brooks said Attorney General Steve Finney's office would oppose any bid for probation only. In Mountain City, Jeff Keeling, News Channel 11.
Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Done. Finished?
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust, and I'll be able to supply you all with the adequate assurance certificate of security to settle and offset the charges.
I still think it's cute how sovereign citizens believe that they can disqualify entire court systems by making a judge or another court officer a fiduciary or beneficiary to their fictitious trust. Because A, your trust only exists in your head, and B, that's not how that works. It's not how it's ever worked, and it's not how it's going to work in the future neither.
Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing.
This is a probable cause hearing.
So I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was.
You weren't able to do what?
Provide my exhibits.
To whom?
To the court to help for my defense, the evidences.
You haven't.
So you're a police officer 24/7, even though you work shifts. If something happens in front of you that requires you to bring yourself on duty, you're duty bound to do it. If you don't do it, you're in trouble. I waited until he finished reading his judgment. When he finished reading his judgment, he asked the other side about costs. I take it you're looking for costs. And they says, oh yes, my lord, we're looking for costs. That's a loss for me. And they asked me my attitude to costs. And I stood forward, took my warrant card out of my back pocket and held it aloft. And I said, I'm a serving police officer in PSNI, and I'm now arresting you for 5 criminal offences. While I was doing that, he was raising his voice and shouting at me to sit down and all this sort of stuff here. So he stood up, and he's like 7'12". He's a big gangly guy, like, and he's like a giraffe. He took off out of the court.
Yes.
Don't stop me.
Judge Williams.
Gotcha.
I don't. Why did you stop me?
You had your cell phone in your hand.
I had my phone like this.
Yeah.
I just lost it. I was just looking for it. Pulled it up like this. Was not on it. I just looked in the. Go up and look.
Okay. Why are you screaming at me?
Sir,
you have your license,
doing
registration, proof of
anything.
insurance. You have your license, registration, proof of insurance.
I wasn't doing anything
Okay.
wrong.
You have your license, registration,
I'm
proof
not
of
going to
insurance.
give you my license and registration.
I was doing something wrong. You
anything-
cannot have a
I had
handheld.
my phone just like this. I was not on my phone.
In what state of West Virginia you cannot have a handheld cell phone?
I drive by a lot of times and y'all are on yours. You're never on yours, right?
Okay, I don't understand why
You're
you're
never
yelling
on
at
yours.
me. Why are you yelling at me, sir?
I said you're never on
Why are you
yours.
yelling at me?
I'm not
You have
yelling at
information.
you.
Yes, you have been. I've never raised my
Let me
voice
tell
at
you something. You all are on yours. I was not
If you read
talking
the code,
on
the
mine.
code says that if we're
Here.
conducting official business, you can be on it. I just don't know why you're
No,
yelling
no,
at me.
no, not on official business. Here.
Thank you, sir. Why are you so uptight? Why are you so shaky? What's going on?
I'm irritated because you pulled me over for no reason.
You had your cell phone in your hand.
I picked up my cell phone because I had it lost.
Okay.
I pulled
You
it
can't-
up here and I had my hand on it here
Okay.
to put it in here.
You
That's
know the
what
law,
you saw.
though. You know the law.
So what? What if I have a cup in my hand?
You can't have a cell phone in the state of West Virginia in your hand.
Give me a ticket. It's ridiculous what you're doing.
How is it ridiculous?
It's ridiculous.
That you had your cell phone in your
Because
hand.
you all have yours. I've seen it many times. Y'all have yours, and you don't get pulled over.
Wow.
a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand. You've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100.
Nice.
Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Steffen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611B, we'd like to introduce a certified register of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of a probable cause conference, and I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is okay. So right here,
this is the probable cause hearing.
All right. It says.
All right. Stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied? Not
because you didn't give me a valid objection.
I object.
You can't just object. You got to explain what the valid objection is.
I object that we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing, Mr. Michaud. Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different day that says preliminary exam.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate columns?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
I understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discussing.
You don't have to tell me what they are. I know what they are.
I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
You're right, Mitch.
Made because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were gonna find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not gonna talk over him.
Right.
And I'm not gonna play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you gotta be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it?
We're literally dealing with a living brain donor. If you would just listen to what the judge is saying, you would understand. A probable cause conference is nothing more than a meeting where a conversation would take place. Now, a probable cause hearing, which is what you're bitching about being forced to waive, is actually occurring today. So you haven't waived shit. I swear, they should give court orders to people like you to carry a plan around everywhere you go, just so you can make up for the oxygen you're stealing from the rest of us.
Because if it's a hearing, or
You
a conference,
didn't
right,
waive it.
so
There-
I
there's
have-
nothing
so
to
do
hold.
I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There-
And in order
There's
to
no
prepare,
preparing for a probable cause
It's-
conference.
it's
It's a
pre-
conversation.
It still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to.
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, the waiver does not preclude him.
Hey, Judd. This is the last video.
You, we agreed to every weekend.
Stop!
I'm here on my behalf to try to get more parenting time with my child.
Mute
That's
him.
it.
Mr. Simpson, can you hear me?
Yes, I can.
We're here in case 14-10108-DP. Mr. Simpson and is the defendant, Ms. Thomas is the plaintiff. How did you give her notice of this hearing?
It was served through the president of the court, served the papers to her.
When was that?
I don't have the exact date that they served it to her, but maybe last week they served it to her. I know I got a sworn letter that she did receive the letter. I got a sworn letter of that in the mail.
All right, was it this week or last week she got it?
Last week, I'm guessing.
You think it was? Do you think that?
No, it was last week that she received it. I think it was on about the 5th or the 6th. I can't recall the date, but it was a sworn.
All right.
Yes.
The 5th would be Sunday. The 6th would be. But all right, as long as you have a letter showing service by a friend of the court, because you don't have her address, I will assume that there's proper notice. This is your motions for child support and for parenting time. First is that, sir, there was just a child support order entered last month, 10/3/23, and you say I just can't afford it and all that. That's not an objection to get a lowered amount. I looked through the amount. It was, you said you make $16 an hour. It was based on $16 an hour. You said you have, I think you're given credit for having an additional child, because you say you have additional child support order, and you were given credit for that.
Yeah, I got three other orders, and I'm making roughly 60. I'm making $16 an hour on a 40-hour paycheck. I'm getting $1,000 taken out of my account, $500 for one child for him, and $30 a week for the other kids. So my misunderstanding is that for one child, I'm paying $500 just for who I'm here on today, Jay Quentin Simpson. I'm paying $500 a month for him and $400 a month for 3 other children. So I'm trying to recommend, because I guess I'm paying some type of rearage or for the birth, but I was just placed on child support maybe a couple years ago because I took up to.
Well, I don't have no kids then, you know? Well, guys, I'm going to end this. Tomorrow is going to be another topic. You guys have a nice evening. Thank you for coming, people. Thank you for coming the last minute and saying hi and thumbs up for everyone. Thank you, Agent. Yeah, exactly. Yep. You guys take it easy. Agent, I'm sorry you come late. It's my dinner time. I have more topics tomorrow. Thank you, everyone. God bless you. And don't forget to film the cops. Bye-bye.